My name is Ian Arrow and I'm the Senior Coroner for Plymouth, Torbay and South Devon. It's important for you to understand that when you come to a coroner's court, you are coming to a court of record. And in that court of record, the coroner is to determine answers to 4 questions, which are: who is the person who has died? How has the person died? Where and when did the death come about? Now, it's not for the coroner to find any fault, liability or blame. There's no person or organisation on trial. The coroner can do it by receiving evidence in person from a witness who gives evidence before the court, or the coroner can receive documentary evidence. That's under Rule 23 of the Coroner's Rules, and the coroner or the coroner's officer will read that evidence into the hearing. When there is a coroner's inquest, as well as answering the 4 questions, it may be helpful for you to know that one of the key purposes of a coroner's court hearing is to ensure the coroner allays the family's fears and concerns. Whilst to them it may appear an unexpected and unusual death, there can often be a perfectly reasonable explanation. And part of the coroner's duty is to ensure that the family understand that reasonable explanation. Now, occasionally, when a coroner hears evidence, it may produce information which, if acted on, could prevent future deaths. So the coroner has power to make a report to a person or organisation that has power to reduce or prevent future deaths. A lot of the cases that come to my court follow from an injury, and more often than that, that is an injury where someone has fallen and they've invariably injured either their head or their hip, which has ultimately resulted in their death. Sadly, we do have a number of falls in the hospital, and accordingly it is possible that a clinical member of staff may be asked to come to court to give an explanation of what has led to that particular fall happening. I'm sure the hospital will have various procedures and policies in place to reduce those, but my understanding is that often there will be a root cause analysis or a SIRI report whereby there's an independent internal investigation to ascertain how that fall has come about. Sadly, it's often because the patient is unattended, but sometimes that's inevitable anyway. So in simple terms, in a simple case, a doctor could be asked to come and give their account of their involvement in the care of that particular patient. That's a simple case. A more contentious case might be where something goes wrong during an operation. There are various high-risk operations, and the coroner is obviously very aware that there is a potential mortality depending on how serious or complex the operation is. So the coroner will be alert to the fact that the family may have particular concerns. They are going to want to know why, unfortunately, it is their loved one who was the unfortunate one who proved to be the mortality in this case. Now, in certain circumstances, that family may have recruited a lawyer. That lawyer possibly to seek further information with a view to pursuing a negligence claim. Now, the doctor appearing in court should not be unduly concerned about that, because the coroner is under a duty, whilst under a duty to help the family, is also under a duty to ensure that only relevant questions are asked of the witness. It is not the purpose of a coroner's inquest to provide clear evidence for a civil claim. A lot of difficulties that arise can often be resolved by a quiet, honest and frank discussion with the bereaved family close to the point of death. Of course, it's a matter for each hospital trust, but I do believe there might be an advantage in recruiting bereavement nurses who might work with the medical examiners to ensure that the families have a proper understanding of how someone came to die. An early explanation prevents fears and concerns developing, as they invariably do if people don't get a proper story to begin with. Well, I think it's well worth going to have a look at the court before you arrive. There would be an opportunity to go and see an inquest that is heard before the one you are to attend, or you could just go and see the empty court. It would allay any fears you might have. It would give you an opportunity to meet the coroner's officer who is dealing with the case. I think it's important that the witness is themselves. It's important that they keep things simple and plain. Please work on the basis that most families will have little medical knowledge themselves. So use plain, ordinary language, particularly in your statement. You will probably be asked for a statement in advance of coming to court. Keep it brief, keep it neutral. Please understand that when you're coming to court to give evidence, you are basically telling the story of how this person came to die. In effect, the coroner is listening in to the story that you are giving to the family. Assume that you have an excellent bedside manner. You will have no doubt honed it over the years, but make sure the family goes away understanding what has happened. When you do come to give your evidence, then rely on the statement that you have prepared. Do ensure your evidence is simple, chronological, factual. Keep the story simple. I like to think that I'm explaining the story to my mother. And once you have given your evidence and the coroner has thanked you, there's nothing wrong at all with your offering your condolences to the family. In my experience, that is very well received. If the family go away understanding, in simple terms, what has happened, you have eminently discharged your duties.